Now, this afternoon, Parliament risks restarting processes to pass the Proper Human Sexual Rights and Family Values Bill again should the President fail to assent to the passed bill. The anti-LGBT bill, passed in February of this year, is yet to be transmitted to the Presidency for possible assent after the seat of government said it will await the outcome of 2 suits at the Supreme Court before taking a decision whether or not to assent to the controversial legislation. The result has been the inability of Parliament to proceed with its constitutional mandate and a protracted legal dispute over the legality or otherwise of the passed bill. We know that NDC flag bearer John Mahama has been speaking in relation to this, but let's try and walk you down memory lane, really. When Roxy Nelson Dafiamekpo's South Dai MP is also one of the proponents of the anti-LGBT bill as has been passed by Parliament. Let's get a reaction from him. Mr. Dafiamekpo, I appreciate that you could speak to us. December 18 is a date set by the court to deliver judgment. Satisfactory enough for you?
Can this be satisfactory enough for any reasonable plaintiff before the court in a matter like this? And how can this be a satisfactory date for any reasonable interested party in this matter? You just saw that the majority leader went to court on the 15th of October, and by sometime this month, a decision was made substantively in his matter. Also on a constitutional matter. This matter went to court sometime in March this year. So December 18th will be nearly a year. And we don't speak of any whimsical issue. We speak about the fact that Parliament's hands have been tied. Parliament has been granted from performing its constitutional duties. That is all we speak of. So if the court says 18th of December to give a substantive ruling on both matters, does it include the interlocutory application that came before them? An application that was heard on its merits and yet they deferred the ruling? You would have realized that ever since this matter went to court, Parliament has not been able to do anything in respect of this LGBT matter. You are aware? You are aware that we've not been able to present the bill as passed into law to the President because of this case?
That's public knowledge.
Yeah, so the Supreme Court, with all due respect to them, if tomorrow their budget is before Parliament and I run to court and say that Parliament should be injuncted from considering the budget for the Supreme Court, would they delay this way? Would they delay this way? Would they tie the hands of Parliament of Ghana this way? I went to court around the same time in respect of the appointment of some ministers of state. The court told me that they cannot tie the hands of Parliament from performing its function.
So what? You believe that the court is picking and choosing which matters it must put preference or priority on as against to that which they feel will go against them?
This is Orwellian justice, and quote me anywhere and quote the phrase. I said this is Orwellian justice. If Orwellian means, go and read the book called Animal Farm by George Orwell. Those who have read philosophy understand what I mean by Orwellian justice. You know, and it's not fair at all. There's no level playing field anymore. I mean, the discretion used by the CJ to prioritize cases, nobody is able to question it. So your matter, as we speak, our e-levy matter is still pending before the Supreme Court. That has not been prioritized at all.
Right.
So for me, whatever the court decides is fine. But the people, the generality of Ghanaians are watching the court as well. Let me conclude by quoting the Venerable Tsatsu. He says, it is not only soldiers who can overthrow the constitution. Men in weak can also do so.
Mr. Dafiamekpo, let's look at the December 18 date. when the court is expected to deliver judgment, it will, in your own words, untie the hands of Parliament to be able to transmit the bill before the president or to the president for possible assent. Looking at the time between December 18 and January 6, 2025, could there be a difficulty for you as proponent in seeing this bill come to light?
By the 18th, we know where power swings. Whether power stays on the left or swings to the right, we will know. And but what is not clear is that whether a bill passed into law by this Parliament and has not been assented to can be properly considered as not having been nearly assented to, and therefore active enough for a new president to be effective for the 9th Parliament to assent to it. That has not been tested, because you know the principle is that anything this Parliament does, if it's not concluded, it becomes caught by fruition of time by 31st December, January 6, 2025. It dies with the life of this Parliament. So I'm wondering whether a bill passed into a law, properly so called, can escape that doctrine.
Right, I'm sure.
We have to test.
Right, I'm sure it's something, like you rightly said, we'll have to check, and we'll subject to a bit more legal conversations and possible education as well.
The next Parliament from this Parliament, nothing, just nothing.
Right. Mr. Dafiamekwa, we'll leave the conversation here and return subsequently. That's South Dye MP Roxy Nelson Dafiamekwa, and also one of the proponents of the anti-LGBT bill, speaking to us this afternoon.
Also on issues around Parliament, renowned lawyer Tsatsu says the Supreme Court's judgment on the 4 MPs vacant seat saga was inconclusive and inconsistent. Expressing his views on TV3's agenda, Chikata highlighted inconsistencies in the judgment compared to previous decisions.
Inconsistencies between what has been said in previous decisions and the reference to that particular Judge KWESI decision. But my point is that at the end of all of that back and forth, citing cases and so on, no directions were given about whether the seats of those 4 have been vacated or not. In fact, what they seem to be saying is that that is a matter which has to be determined as a matter of fact in the High Court. That's my reading of the judgment, that it has to be determined in the High Court. In a sense, we're back to square one.
On the same program, former national chairman of the NPP, Freddie Blaze, said the court's judgment is practical.
But I don't believe that we're back to square one. From my understanding of the judgment that I've had time just this afternoon to go through, and confirms what some of us have all this while have held on to, saying that the Right Honourable Speaker's position on the matter was wrong. Essentially, it was from the long statement that he read, which Tsatsu has referred to as the formal statement that communication. He made it clear. Of course, he spoke about the reason for standing firm against cross-carpeting and went about it in a way. But the issue was, he was interpreting 97G, 97H, essentially. That's what he was doing. And by that interpretation, he made it clear that those who have picked nomination form and maybe filed, and the polls maybe coming out, is taking judicial notice of their taking those steps. And he was therefore reacting to what the minority leader had drawn his attention, and he went ahead to say that definitely are no more members of Parliament, and that's the central point, and that's why Markin went to court for interpretation. I think after going back and forth with him, saying that let's see what we can do and have to, we were remaining only about 2 months or 3 months. But of course, they did not disagree. He took a different position, and then Markin also took a different position. And as I said, as I sit here, maybe I've taken a different position for my lecturer, Tsatsu. Definitely, I disagree that interpretation is like that. When you say you are living, you will leave. You are living and you've left. Interpretation are a bit different.
We'll go to the interpretation bit,
but let's be clear.
Yes.
Now, NPP Constitutional and Legal Committee Chairman Frank Davis has dismissed calls for an electronic mode of selection for empaneling judges. His comments come at a time when a former justice of the Supreme Court, William Atuguba, condemned the empaneling of some Supreme Court justices on high-profile cases. Lodis Eduasare reports.
A retired Supreme Court judge, Justice William Atuguba, on Saturday heavily criticized the empaneling of judges at the Apex Court following its decision in the parliamentary vacant seat suit. He questioned the motive behind the selection by the Chief Justice and noted that politicization of the courts had surged under the current administration.
Look even at the empanelment. People has referred to all those. I mean, for what reason will you bring the younger justices to handle such a weighty matter to the exclusion of the seniors? What reason? I mean, this reason, sir.
Director of Legal of the National Democratic Congress, Godwin Eduji Tamaklo, pleaded with the Chief Justice to deploy an electronic selection process.
Would she have the courage to trigger an electronic empaneling of the judges? Because an electronic empaneling of the judges would definitely ensure that you have a perfect blend. Because if it's an electronic system, you build the algorithm in such a way that it takes cognizance of the different shade of justices on the bench.
In a quick rebuttal, however, New Patriotic Party Constitutional and Legal Committee Chairman Frank Davis indicated that any such move will be counterproductive.
You want a computerized empaneling of judges, computerized, electronic, and you think that cannot be fidgeted with? When we have justices in the Supreme Court who have gone through constitutional vetting and have won the approval of an appointments committee in the House of Parliament or the Chamber of Parliament, I mean, what again do we want? And then at the end of the day, we doubt their integrity and their fidelity to the law and to the Constitution. No, I honestly don't think it's fair.